Hey guys, and welcome to the weekly docket. Hey guys, and good morning for Saturday morning or afternoon or evening, depending on the various places that you guys are, assuming the rest of the world actually exists. Got a lot of cases on tap, so let's see if we can get into these really busy weeks. So some of what I wrote may be as much of a surprise to me as it might be to you. And let's get this thing going here. First on the list is Darrell Brooks, and some questions in the chat about that. So I don't know all the answers because I couldn't get a hold of the lawsuit, but let's take a look at it. He was sued by several people, and two of them are minors because the guardian ad litems have been appointed. And you see on here involuntary plaintiff, and I don't know if I get, and a defendant. So Wisconsin does things a little bit differently than some states do, in that these lawsuits for personal injury, the insurance companies get named sometimes as involuntary plaintiffs or defendants, and we don't do that here. So that's a little different. So I really wanted to see the lawsuit so I could actually answer what's going on with it, but I couldn't get it. I called the clerk and they said you have to fax in a request. So I did that, waited a couple days, did it again, and I just never heard from them. So maybe they don't want to send it, or maybe they don't care. I don't know. It's not showing it sealed or anything like that. So I can't say. Obviously, Darrell Brooks is not solvent, so there wouldn't be a good reason to think you'd get money out of him. Although sometimes you want to get a judgment against somebody just in case for the future, right? That he wins the lottery or his mother does and he inherits it, and then you can get it from him, something like that. But with all these insurance companies named, and it looks like on both sides of it, then it is potentially an insurance issue. Now, whose insurance? I don't know. I don't know if it was insurance on the vehicle or some kind of underinsured policy or something else. I just don't know. I don't have the lawsuit, so I can't really tell you the answer to that. Now, generally, if you're in a civil suit, the state's not hiring you an attorney to defend yourself or to prosecute a civil suit, right? But if there's insurance involved, they usually will proffer a defense attorney. And on the plaintiff side, that is typically a contingency fee situation. So that's how it normally would go. And I'm assuming that here, but I'm not assuming that he has a defense attorney yet, because nobody's posted anything up, and I don't know whose insurance is really doing what here. Now, assuming that no insurance wants to take over in this case for Brooks, does he go pro se? Does he let it become a default judgment? I don't know. I don't know the answers to that. We have to wait and see. The docket will show that eventually, because there's a time limit on responding to the suit. In terms of his criminal cases, nothing's happened that I see on that either. You know, the judge had inquired about, hey, are you appointing a new counsel, public defender, or what's up? And as of this morning, I didn't see any action on that. Somebody saying, I heard that it was their own insurance since her SUV wasn't insured. Right. See, and so that's possible that it is. Certainly. Why you would need a lawsuit for that, I'm not sure. You know, there could be an argument over the amount of limits that are involved in the case. Could be an argument over why they haven't been proffered. Could be an argument over, you know, if there's multiple paying parties needing some kind of adjudication on who has to pay what. Well, I don't know. I mean, it seems like a lot of these injuries you would suffer to the limits of whatever your uninsured or underinsured policies are. Insurance works different in different states, but my feeling is it's probably something related to that, but I just don't know. I just don't know the answer to it for sure, but good thought on that. And that definitely could be right. Well, look at that. Got a new member here from Scotland. That's awesome. It adds additional pressure to come to Scotland. And Raleigh right now looks a lot like it, because it is foggy and rainy out here. And we'll be out, hopefully, in the woods in a little while, getting wet after we do this, some other errands. So thanks for becoming a member. Check out the member streams if you want to know particular aspects of law that the members have voted on. We got lots of streams going over some pretty cool stuff there. And free stickers, if you want them, be glad to send them to Scotland. All right. So let's move on from Brooks. I think we've covered that as much as we can know. I just couldn't find the lawsuit anywhere, and I couldn't get it from the clerk, so I don't want to speculate too much about what it is about. Go out west a little bit to Bryan Kohberger, and it's not as bowling over as it has been, but a couple of developments. The critical motions in the case were postponed. I think somebody said somebody was sick, and it looks like the defense team, that was them, and the state said, hey, that's not a problem, so they've reset those motions for October. That's fine too. They are still arguing, however, about the cameras. Let me stop here because I think I'm missing where some people are. And so good morning to Oklahoma. I think I saw California earlier, and I know we have some other continents in the house as well. These people were not hurt. They're suing their own insurance and insured. Yeah. So see, this kind of thing makes some sense to me. Yeah. And if I can find news on it, I'll try and read up on it too. That's logical from what I'm seeing, but I didn't catch a news story on it without reading the complaint. I don't want to tell you something as if I know it when I don't, but that makes sense to me. Good morning to Texas. We won't mess with it. And South Texas. How about that? That's cool too. Texas is so big, they have to have a South Texas and a North and East and West and all that. Virginia just has Northern Virginia for people to say, to make sure they're actually DC. That's why they do that there. Into Michigan, a cool place that can get quite snowy. All right. So my wife is typing a comment right now, but if she wants to relay something that I can hear, I'll let you know. But, well, she's typing something. Maybe it's a comment. All right. So now what's going on here? Kohberger's defense attorneys have replied to the media who says, hey, we need to have these cameras in a courtroom. And I want to show you some of the law that they're citing to make sure you kind of know what's at stake here. And remember, if the judge lets cameras in a courtroom and then an appeals court later on finds, assuming there's a conviction, that it impaired his right to a fair trial, you could lose the conviction. So the judge has to be careful here, even though the judge has to weigh the public's right to know and to watch judicial proceedings. You have to weigh that against the fair trial. And the defense is also citing some Supreme Court cases. Let me hit this. Yes, she did. She's born in Grand Rapids. And all right, I think that's Georgia, which is cool. Got Georgia on my mind, and London, UK. And I will honor you by not attempting any further English accents. And I'm reliably informed by my wife that I do a poor job of that. I can do a pretty good Southern accent, Southern United States, Montana. I'm beginning to get jealous of all these locations, I have to tell you, especially since the weather we got right now. All right. So let's see what the Supreme Court says. Maybe you already read it. The television camera is a powerful weapon. Intentionally or inadvertently, it can destroy an accused and his case in the eyes of the public. While telecasters are honorable, two are human. Are we sure? The necessity for sponsorship weighs heavily in favor of televising only notorious cases, and it focuses the lens upon the unpopular or infamous accused. And they're saying there's a profit motive for that, which is understandable. And public sentiment can affect trial participants to the extent that television shapes sentiment. It can strip the accused of a fair trial. Now, if you're a defense lawyer, boy, do you love that sentence right there. And not surprising that they would point that out to the court. Another Scot. And then this state has a lot of Scottish people too, or people of Scottish heritage. So it's fascinating to see the connection to that. Another member. So congratulations on that. Check out the free stuff you can get, and also the behind the scenes videos that we do where members vote on it. And we talk about whatever you guys choose. Although everybody humored me last week or earlier this week for hearsay, because that's confusing. I wanted to go over it. Born in Estonia. That's cool. Yeah, Pacific Northwest is the low 60s as highs. And I think it's in the 60s here right now too. We were there, I guess, just over a year or about a year ago or something like that in the Northwest. All right, let's carry on here. Sorry, I just enjoy seeing where people are from. Okay, so the defense carries on in the Kohberger case, saying in particular, the Chandler court emphasized the conclusion that there's no constitutional requirement that television be allowed in a courtroom. Obviously, federal courts don't televise things. And at least as to a notorious criminal trial, the considerations against allowing televisions in the courtroom outweigh the countervailing factors advanced in its support. So in some cases, they say the presence of the television can cause an unfair trial. And that means if you go to all the work to get a conviction, it gets thrown out. So the judge has to weigh all that. And I think somebody made a comment here again about the situation in a Vallow case. And I agree. I think the prosecution suggested that to the judge. You could allow recording of it, put it on a delay, and that would be a middle ground. And catch some more of these. Indiana, and we will travel to your state shortly in this situation. Still in the 90s in Texas. That's cool in Texas, though. And, I don't even think in Texas they try to lie to you that it's a dry heat. You can't tell that lie in Texas. It's a wet heat. You have to jump in the pool in Texas in the summer in order to dry off. That's how high the humidity is. Let's see. Let's get to another slide here, and I will. All right. So the defense says the proceedings are not entertainment. We all agree with that. The chief function of our judicial machine, or black part of that, is to ascertain the truth, and that's what it should be, but it's not always true. The use of television, however, cannot be said to contribute materially to this objective. It's an injection of an irrelevant factor into court proceedings. And experience teaches there are numerous situations which might cause actual unfairness. Yeah, I don't know that it's irrelevant. I think the public's right to see things is important. It's a weighing function, okay? What is estoppel? Here's a question. What is estoppel? Why did Brooks say he didn't consent to it when the judge left the room, went off the record? Well, estoppel is sometimes when a court can say, well, I'm not going to allow you to do this thing because of your behavior, right? Sometimes you're stopped from pleading the statute of limitations or something like that. It's kind of a fairness thing. But he's just using words, and nothing he said actually invoked any concept of estoppel, nor did it matter whether he consented in any material way to what the judge was doing, leaving the room, or it can matter his consent when he's pushed out of the room, but that's why she was always quoting the Illinois versus Allen case. Brooks was streamed and that turned out fine. Yes. Now, having said that, fine in terms of the public's aspect that this completely guilty dude went to jail, prison where he's supposed to be. But what the defense will say is, not in the Brooks case, because, he was so guilty, that the coverage can sway trial participants, jury pool, the sense of the community and things. And you don't get a fair trial if everybody's already condemned the person. That's the argument they're making here. And the judge has to evaluate it. It can put a case at risk. I agree with you. I don't think it did in the Brooks case. Now, remember, they were looking to change venue and stuff like that. So publicity can matter. It definitely can matter. Oh, man, come on. You're just dunking on me now. In Kalispell, come on. Wow. All right. That's cool. Okay. All right. So let's finish up with this Kohberger stuff here and get to the more exciting things, because this is just arguing over the cameras. The interveners are the media is what they're talking about, that the benefit is unfettered press access and providing the public the opportunity to observe firsthand how the criminal justice system is working in the case. And that is important. I think that is helpful. But implementation of the requested restriction is not as draconian as the media seeks to portray. So they're saying just take the cameras out. We're not asking the case to be closed or closed hearings or things like that. So anybody in the community, including media, can come to the hearings. And they make the point that the people most affected by the case who are around there can come there. And of course, the judge has let victims' families and stuff come by Zoom, even when the public's not seeing some of this. So I think we can all see that with the state saying they agree with the defense, basically, and the defense doing this, the judge is likely to put a restriction on this, but we won't know until he does it. They did do it in Vallow, so I could see that happening. All right. So here's a comment. People will burn you at the stake for saying that you think Kohberger did it. Well, I think he did it too. We have to see the rest of the case and the quality of the evidence and things like that. But I do believe it. One reason why I would not believe it is because it was impossible for him to do it. That's imagination there when people throw that out there. And it's possible to do a lot of things if you're a motivated individual. Probable is a different situation, but when you tell me impossible, I start to get skeptical. Never say never. All right. So Sarah Boone, so something popped up on her docket this morning when I checked that out during early morning coffee. That was interesting and something that you don't see all the time. But first, here was the court's ruling after the withdrawal of the sixth attorney, setting the case for December 11th, 2023. But, that's still doubtful to me because the new guy's got to get in, and can he get up to speed? And if he wants new experts, can he get them ready? let the state question them or not question them, but prepare their own experts to rebut whatever these expert opinions are going to be. Can all that be done by December 11th? I don't know about that. So I would still think this case goes into next year, but it's just guessing. But look at this. Notice of provisional supplemental discovery comes now the state of Florida by and through the undersigned assistant state attorney and pursuant to Brady versus Maryland. Now, if you know what Brady material is, that's material the state has that could be exculpatory, right? Indicating innocence. Hereby serves a notice of the existence of the following information. And they say that Chelsea Copsall is under investigation by the Orange County Sheriff's Office Professional Standards Section for matters related to unsatisfactory performance. And she's a witness for the prosecution. Oh, yeah, she is, because she was a detective on the case. I think this was the lady who was, woman, sorry, traveling back to the 60s. This was the woman who was interviewing Sarah on the video they have where she was, Sarah was like, oh, I didn't do it on purpose. I don't want to watch these videos and stuff. Now, if you want to imagine somebody's not guilty, and there aren't too many Booners, who are pushing that in this case, but there can be more in others. You get excited when you hear Brady material because that can be something that indicates the innocence of the defendant, and the state has to turn it over. But there's also a case called the Giglio case, and so police departments will carry, or law enforcement will carry a list called a Giglio list, and that is for purposes of impeachment. So the courts have said that not only evidence that shows innocence must be turned over, but also if you're going to call a witness and you know a good reason why they could be impeached, you have to let the defense know that too. So if an officer engages in something that's misconduct, or here it says under investigation for misconduct, then they're supposed to tell the defense that, so the defense can check into it and see if that's some way they can impeach them in this case. That also happened in the Kohberger case, where some officer, they had to say was, had some disciplinary thing going on. Now, that can be very material to the case, or it can be something that isn't really material, but that's something you have to turn over. So that is interesting to see that pop up in this case. I think it doesn't probably really matter because I don't think this detective was setting her up, and everything that, that we see, I think that indicates that she's guilty of stuff. You see her talking herself on video. But if I'm Sarah Boone or a Booner, I'm going to look at this and go, aha, she's been railroaded and she hasn't been able to tell her truth. Look, she's got a corrupt officer because all police are corrupt and that kind of stuff. So, and here's a comment that says, it seems like the police didn't hand over evidence in the Delphi case. So yeah, we'll come back to that because it can be important. Here, I don't think there's any question about evidence being turned over because, there's not much mystery to this case. She was the person who was there and who left him in the suitcase. Even she doesn't dispute that. She just disputes the circumstances. So I don't know how much evidence there is in this case that really matters. But they're doing their job and telling about it. So, yeah, I agree with this sentiment in this case. Interesting, but won't do her any good. But, it's the kind of thing, if you don't tell it and they find out later and it's important, you don't want to put your convictions at risk, assuming you get one. And if you don't get one, you don't get another chance anyway. And then here's the signature line where Winston Hobson has come into the case. I showed the first page of his filing the other day. It's 4 pages, but it's all just a form saying that, she's pleading not guilty and she wants all the information from the state. And that's been filed before. That's fine. It's a form pretty much that he's putting in there. And he's in the case. So lucky number 7 is on the scene for Sarah Boone. And that's what I have seen there. Let's go down to South Carolina, the worst Carolina of the two, in my opinion, but, I'm biased. So look at this thing, received the 21st of 2023. I just saw this morning. Everybody knows that Murdaugh made a filing at the Court of Appeals to go back to the trial court level and see whether the conviction should be thrown out for improper communications between a court official and the jury, right? So they want permission to suspend the appeal and go back and do that. The state filed a response, which basically said he should have filed an affidavit in support of that, and you should give him time to do that. But if he does, yeah, it probably should go back. So there's not a much argument here. Nevertheless, Murdaugh's attorneys have come back pretty strong, even on that pretty light statement here. Here's somebody in Charlotte who agrees that South Carolina is the worst Carolina. But, whenever you leave North Carolina or South Carolina, everybody just wants to call it the Carolinas. And I don't know that anybody in the Carolinas really enjoys that, but maybe it'll get more like that. So anyway, so Murdaugh's attorneys say that the state invents a preposterous procedural requirement, right? And that Murdaugh must provide an affidavit. They say that's ridiculous. And I kind of agree with them there because, Murdaugh's not in a position really to hear about this or know about it after he's incarcerated. His attorneys and the jurors would have been the ones handling that. And in fact, they say an affidavit from a juror that the clerk of court told jurors not to believe the defendant when he testified is sufficient to establish a prima facie case for a new trial. They're probably right about that. If it were to turn out to be true, when they say prima facie, they don't mean proven. They mean that this is enough to say we got an issue here. And the state didn't contest against that in their filing. So then they say they should require Murdaugh to file this affidavit saying he didn't know Ms. Hill was tampering with the jury during the trial, and that the attorney general knows he doesn't have to do that. And then they put this footnote down here, which puts it all to rest, that they did do it. They went ahead and got this affidavit from Murdaugh, and they attach it as Exhibit A to the reply. And so I think we will see this come back for hearing. And it'll be interesting to see if it goes to Judge Newman or not. But there will be a hearing on this, and there should be a hearing on this. That doesn't mean it's true or not true, but when you've got affidavits supporting these kind of accusations, a judge should look at it. So I have no issue with that personally, even though I think he did it. And most lawyers that I talk to, they don't agree with me on that, but that's my opinion. Now, he's also appealing everything. I put in the notes before I did this because I looked him up in the Court of Appeals, and here you see that he September 20th has filed a notice of appeal in the Satterfield matter. Nice. And he had already filed a couple months ago, I guess, an appeal or an attempted appeal in the Beach case because they want money to pay for his criminal appeal, and they didn't get it. I think that's actually written on there. So lots of litigation from this. That's what happens when you get a lawyer as a defendant in court. You get lots of litigation. Now, somebody said he was smiles in court the other day. Yep, check this out. Convicted murderer Alex Murdaugh. He pled guilty to a crime. He pled guilty in federal court of 22 counts of financial fraud. And what he's seeking there is for those counts to have concurrent sentences and to run concurrent with any state sentence. And I'll tell you what the angle is. This is the next slide. His theory is if he can get the murder convictions thrown out and not be convicted of that, and if he gets federal charges that are concurrent to state charges, that kind of makes the federal irrelevant. And then for the state charges, if he can get those put into some kind of situation where it's not life, then he can get out of jail someday. That's their long game that they're playing here. And that's why I have this up here, the 99 strikes and you're out, because I think they have some kind of 3 strikes law in South Carolina. And the way that Waters is doing this, it would apply to Murdaugh, and his attorneys don't want that to happen because they want these sentences to be such that he might get out of prison at some point. And that's, they're his defense attorneys. They should do that. So but I think that is the strategy there. And good morning to Marshall Lynn, who is a Texas individual, and thank you for supporting the channel. I appreciate it. And you do that often. And I appreciate it a lot because it costs money to run this thing. Trust me, it's not a profit center. Let's go to Indiana. We have somebody watching from Indiana, so I'll be as careful about this as I can for accuracy purposes. But of course, we're talking about the Richard Allen case and the murders of Libby and Abby on the Monon High Bridge. And you see the pictures, and the big controversy down there on the bottom right is that Richard Allen or not? Some people think it is. Some people think that picture itself proves it can't be him. And some people like me say, I don't think you can tell for sure about it. The picture it's unfortunate because that's the person who told the girls to go down the hill while he was holding a gun. You can hear him, you can see him, but the resolution is just not there. So that's one of the things that's been so interesting about this case. Obviously, it's terrible because of the murders, but that is so close to the girls actually providing the evidence needed to catch the person. I mean, they certainly tried to do it as they became nervous at this person approaching, rightfully so, because that person abducted them. Whether that person killed them or not, different story. And that is not what Allen is charged with. Really, he's charged with the abduction under felony murder, which leads to their deaths. They didn't say that he's the one who used the knife on them. And we don't know if the theory needs to be one person or more than one person to convince a jury, but the state has not closed the door either on multiple assailants. So there was this filing by the defense, which was quite long. I did a video on it the other day, and it's for Frank's hearing. And the purpose of the hearing is not to prove that Alan's innocent or anything, although you'd think that was the purpose of it from this brief that they filed. But it's to show the court that the police misled the judge who granted the search warrant in a material way such that the search warrant should be invalidated and the evidence that came as a result of the search warrant should be suppressed. That's the goal of the filing, the legal goal of it. I think there's also a PR goal in terms of telling the public his story and maybe also telling the judge as much of the story as they can so the judge can see their point of view. I think they were both being done there. I did hear another lawyer say that if they were to succeed in this, then they would also ask that his confessions be suppressed because he would never have been incarcerated if they didn't get probable cause or affidavit to get this other evidence and then use that to arrest him, that he wouldn't have been in jail, wouldn't have been recorded talking to his wife, apparently confessing. That seems a bridge too far to me, but I haven't researched it carefully. But the certain thing would be if they were to win this, there would be a good chance they'd throw this gun out. And whether that's important evidence or not, it's the only physical link that we know of that's even alleged by the state to connect him to the scene. So that would be important. And I think obviously a large part it was to tell his whole story. So, why would his lawyers continue a conversation with us in regards to listening and recording? Ethical violation. And it depends on probably on the content of the conversation there. But a good point. And I'm coming back to this here in a second about the recording and all that stuff, which is not good in my opinion, but still. All right, let me get what I'm trying to say here. So if you remember back a month or so ago, or a few months ago, they filed a motion asking he be transitioned from where he's currently incarcerated to some other place. And they listed all these horrifying conditions he was undergoing. It showed the picture of him with stuff on his shirt that looks like me at any given Friday night dinner. After it's over, he's got stains on his shirt and therefore he's being tortured and they can't get to him and all these things. So they wanted to move him somewhere else. Now, I personally thought that given he's only charged and not convicted, that the judge should listen to them carefully on that. And if there was a place that would allow his attorneys to work with him easier, better, less time and interference and stuff, that's a legitimate issue. But they also put a lot of things in there about like, he has to sleep on the floor and get up early. And a lot of the stuff, I'm like, it was worse than the Army than this. And actually the judge ended up finding that the allegations were unsustained. And the judge disagreed with their characterization of how he was being treated in prison after listening to all the evidence. So they didn't succeed there. And I think they had a good point, and then they covered it up with a lot of emotional stuff that just didn't fly, didn't make sense to me. And when you do that repeatedly, you start to lose maybe a little credibility. Like I'm going to eventually start assuming some of what you're telling me is nonsense if you keep doing that. And here's my issue with their current filing. So there's a logic to what they're doing, I think, in the first part, which is the police themselves thought that this crime scene was of a ritual nature. Okay. And if that's true, then that's good to point out because that's important as to who committed the crime, either because they wanted to perform a ritual actually and posing things for that, or they were trying to stage it to fool law enforcement later on. It's still an insight into what was going on in the killer or killer's minds, right? And then they say that this was potentially linked to this whole Odin thing originally, even by law enforcement. So the defense is saying, we didn't come up with that. They came up with it. They just didn't want us to know about it. And then they basically make the case that Alan's not connected to anybody that has anything to do with Odinism. Now that does matter to me. I mean, that's okay. I hear what you're saying on that. That's if it's a unique kind of crime, what's this guy got to do with it? What's the state going to say about that? Now, also, they said that there were other suspects or people who should have been suspects that the police didn't tell the judge about because the police had ruled them out. Well, I mean, I don't think the police have to tell the judge before they get a warrant on Alan every single person they've ever thought about this case. But I think to rebut what the defense is saying, the state will probably come back and say, well, yeah, Your Honor, we ruled them out because it was this alibi and that alibi. Why would we tell you about the 15,000 tips we had in order to get a warrant on this one guy where we have the most information on and believe this is actually the person? So the state probably has some responding to do there, but I follow what the defense is saying there to some degree. Okay. But they keep going with this Odin thing, and the Odin thing starts to encapsulate everything that they think is bad about their case as some kind of Odin cult fault. Right. And to me, the Odin guards, that's a tiny ninja too far. Okay. All right, so the guards wore Odin patches. They shouldn't be doing that if that's true. Although, if you're around any kind of tactical people, lots of times they wear patches that couldn't be serious, or they can just be for fun. I've had Flying Spaghetti Monster ones and Umbrella Corporation one, which I still have, and I do not work with the Umbrella Corporation, and I'm not actually an adherent of Flying Spaghetti Monster stuff. And if somebody from that FSM killed somebody, it doesn't mean that I'm associated or aligned with them. So I don't know what to think of these patches. Not a whole lot I have to guess or think. But let me say this. Their point of the Odin stuff is that these Odin guards coerced or induced or pressured Alan to confessing. So you're an Odin-liking guard, and these other Odin people murder these two girls. And because you're both Odin people, you got to cover up for the murderers. Is that what we think of Odin people? Like they're all either willing to murder people or willing to cover up a murder for people? Because if you're not saying that, then you need to show me how these guards are associated with these other suspects that you're trying to protect by having Alan falsely confess. That's nonsense to me. And then unless you have evidence, right? Because people can imagine anything. The judge could be an Odinite, right? Alan's wife could be a secret Odinite, and then she cajoled him into confessing. You can put Odin on anything if that's what you want to do. And look how they allegedly induced him to confess in a phone call to his wife. So if you're the Odinite and you want to make sure you protect your buddies, why wouldn't you have Alan, assuming he's going to do what you want because you threatened him? And that's kind of what the defense insinuated. So what you want him to do is to take the fall. Why not say, when we come back tomorrow, you better have written on a piece of paper that you did it and how you did it and all of that. And we'll put it in an envelope and send it to the judge. And here's a confession, or we'll send it to the newspaper and here's a written confession. Why not tell him, if he's susceptible to these threats, if you don't plead guilty, then, this bad thing is going to happen to you. The phone call to the wife, and the Odin guard's like, that's all we wanted, man. Hey, you told your wife you did it. We're totally sad. That was our master plan, was to convince you to tell your wife you did it while we wore Odin patches that's associated with a crime scene, because that's brilliant. Now, one of the other things they did was say that Alan couldn't tell them if that had happened, which, by the way, was purely hypothetical, because the guards, maybe the Odin guards, were filming him from outside the cell and they could see his mouth. I don't think it was necessarily contention that they could hear him, but just they could see him. So he couldn't tell them if it did happen. So how do we know it didn't happen? They didn't say it did happen. They're just more like, well, how do we know it didn't happen? But you know what? If you go back and look at the docket, you'll see that was an issue that was brought up earlier this year. And in June, the court notes on the docket that Department of Correction had said they will no longer video him even from outside the cell if he's in any meeting with his lawyer. So if he was wanting to tell his lawyers about this pressure, after June, there was no recording. So why hasn't he told them any time between then and now? I mean, I would imagine they've talked about it. If your client's confessing to other people, one subject to conversation would be stop confessing to people. And then that a follow-up thing could be, well, but the Odin guards told me I had to tell my wife that I didn't. Oh, they did? Okay. And then you have, this potential defense, but that's not alleged in their motion, just that it could have happened and all that. So I think the Odin guards are a tiny ninja too far. That's my opinion. Well, let's see what you guys. So here's a comment. Any pagan nonsense at the crime scene was misdirection, and so is this defense theory. That's certainly possible, right? And here's another thing. Okay, so the defense gets the first crack at describing the crime scene because the state hasn't done it and nobody's done it yet. Nobody's said what this crime scene was. And it doesn't, I'm not saying it's wrong, but I am saying I do not take their description of the crime scene as accurate as that's a settled fact. Even if some of the physical characteristics of the crime scene are as they say, it still doesn't mean their characterization of the crime scene is a fact. Because when I started out in this, before I got licensed, I worked at Department of Crime Control and Public Safety for a while in profiling. And one of the big topics back then was ritual crimes and the satanic cult behind everything and all that. So some of the training for law enforcement around this state was to see things at a crime scene that might indicate that. But then also, because it became a panic where like everything is that. Also, just because there is a symbol on a graffiti somewhere doesn't mean that somebody who is killed a block away was killed by some kind of cult, right? Or a candle or something, a stick a certain way, or a dead chicken part or whatever. That you could find a ritual situation sometimes when there was not one. So I would like to see, although I don't know that we'll get to see, the state's response to this and how they characterize the crime scene. So I think there is an indication that they may agree with a lot of this, but I don't know, and I haven't seen it. And on the docket, it doesn't appear anything was filed. And if it gets filed, it doesn't mean we'll be able to see it because it could be sealed or whatever. So, yes, I like this. The master plan was to make it an obvious Odin ritual, then frame someone with no Odin ties. Yes, exactly. They should have left what they work at CVS or something. Maybe leave one of those empty photo packs there or something like that. Now, I will say, I respect what you're saying that this could have been staging. It's a lot of effort to stage. So I don't know. I don't know if it's some weirdos. And just because, let's say it wasn't ritual style, doesn't mean it's these Odin people. I don't know about it. And it also doesn't mean that it took more than one person. I can agree with the defense that because the state seems to follow this logic too, that there's a good chance there was more than one person. Maybe you could call it probable, but you can't say it's impossible for one person to have done it. And for example, they tried to act like, well, he's only 5'4". He couldn't get across that raging river with these two girls, but the girls got across it. They did get across it, whether it was an Odinite taking him across or whether it was him, he can walk across that. So there's a lot of stuff that they put in their motion that just doesn't stand up to logical scrutiny. And when you throw so many things in there, if you have a couple of good points, to me, they can start to be lost in this. There's a lot of smoke, but where's the actual fire at? So I didn't find it fully persuasive. And they also ignored some of the time frame evidence and things like that. Who came up with this Odinite nonsense? Well, I assume that's been around for a long time. I don't really know. But, when the Vikings show came on, I mean, who didn't want to be a Viking, man? They were all doing Odin stuff, I think. So I wanted to be a Viking, but I can't be one. But would I like to be one? Yeah. Oh, yeah. Yeah. There's lots of swords here and stabbing things and throwing axes and stuff. So, that may have caused a lot of these patches you see up here to start showing up around ranges and things like that because they're, trunk monkeys and there's all kinds of patches people put on their stuff and they're heading out to the range. So there was a sandbar there anyway. Yeah, I don't buy the fact that the girls could make it across, but he couldn't. I don't see that one. So yes, sticks in the woods, Odinites for sure, but one of them may have been cut with a saw. Okay, so they brought a saw and they only cut one stick. It's a lot. It's not conclusive. Now remember, the real point of their brief is supposed to be to show the judge that the judge who issued the search warrant was materially misled by law enforcement. But there's so much stuff in this motion, it's easy to lose sight of that and start challenging all these other things they say, which really don't pertain to that in any material way. So I'm not saying anybody has to believe he's the person who did it. I am going to say that this motion doesn't convince me that he didn't do it. But I think it does raise some questions and ultimately will, be a part of the trial if there is one ever, or maybe part of the state's response, which is what really is the situation with the crime scene. They've kept it secret and that's understandable. But, I can't say for sure that I agree with how, the ritual nature of it. And if there is one, does it really indicate Odin stuff or just people doing weird things? Because there's a lot of weirdos in this country. So, yeah, I mean, if your client has confessed, you want them to not do that. And you want to come up with some reason why they did it. Now, the two theories were, one, he mentally lost it. And we don't know what the confession was, right? That maybe he should have said something like, or could have said something like, well, they keep telling me I did it. I mean, did I block this out? Maybe I did do it, something like that. I think it must be a lot worse than that because they sure are spending a lot of time trying to rebut it before it's ever actually time to rebut it. Okay, so, but we don't know what he said. But the more the defense talks about it, the more I think, yeah, he must have said something pretty directly bad for himself. And why would he do it? I always think, well, why do people falsely confess to anything? But the reality is sometimes they do. So, you have to look at it in the context and stuff. But the context right now is the defense is pushing for Odin pressure is the reason why he did it. And originally they'd said, he lost it mentally, kind of went crazy and stuff. And if that's what you're standing with, fine, you're going to have to show that. But now they kind of added on because the Odin guards and that now I start, drifting away. It's time for me to get up and go get a snack at the snack bar and eventually leave the show early because they have lost the plot with me. West Texas is low humidity. Heat is easier to cope with. Yeah, the dry heat theory is real. I guess the parts of Texas that I mostly spent time in is where they stack all that humidity up at. How about Sidney Powell? She was in college, then she got booted out. Her parents were figuring it out. Her mom got on the phone with the college administrator, and just as they were beginning to discuss it, she hit her mom in the head with a frying pan and then stabbed her to death. And then picked up the phone when the people called back and they asked for the mom and said, "Is this Brenda?" And she goes, "Yeah, this is Brenda." Well, it wasn't Brenda, and they knew that, and they called the police, and the police come over there, and she was fronting for her father and the police that someone broke in and attacked the mother. Now, the issue with going for insanity is it's not whether you're hearing voices necessarily, and it's not whether you've gone crazy or had a break or whatever. The idea is at the time you're doing these acts, either you can't control yourself or you don't know the difference between right or wrong. Not whether you agree whether it's right or wrong, but you don't know the difference. And one of the classic ways in the good old days of showing that somebody did know the difference between right and wrong is if they immediately take steps to cover up what they did. Because if you're immediately taking steps to cover up what you did, it suggests that you know what you're doing is wrong in the eyes of authorities, or else why do you have to make up a burglar coming in and doing it? And potentially that's what the jury saw here, because it was evidence of her lying a lot right from the beginning. But her family supported her and wanted her off. She hasn't stabbed anybody else, seemed to be the theme of that. And she's so much happier now that she's on medication, but now she's going to go to prison for a while on this. And I gotta get Arkansas. Arkansas has low humidity? Or you're saying you enjoy low humidity as I do whenever I can find it, because North Carolina is a high humidity scenario. Odinites didn't make Allen the only male on that bridge in a roughly 30-second window. He had to cross paths with the girls. They're not that magical. Yeah, I agree with that. If the defense wanted to convince me of that the state's theory on the timeline was completely wrong, they needed to do some more work on that, because the description of the person didn't do it. And the only thing I think they scored a point on to me mentally was the car. And I already talked about that in the video. That I don't think that bounces his prior statement that he saw 3 teenage girls and that 3 teenage girls saw him, and that's the only people he saw, and they didn't see any other guy. That starts to lock him in that box that it drew. And then the next female witness locks him in further, and they got to get out of that box. So I get upset when people, and this comment, when people blame mental illness for their actions. Yeah, and a lot of people are mentally ill. Does that mean that they're violent? And the law, at least in regards to insanity, is a specific, because insanity is not the medical term, it's the legal term, and it's a very limited. And it isn't whether you're mentally ill, it's whether, pretty much you could conform your actions, or you didn't know what you were doing was wrong, is kind of the theory here. And there was objective evidence, I think, that suggested here that she did know that, because she broke a window to make it look like a burglar came in and was lying about it. Right. So I think she did. I don't know why she did what she did, but if you start, people shouldn't murder people. And if you murder somebody in your family, there is something wrong with you. Take Ted Bundy. He's way crazy. So let's just put him in a mental institution because he's totally crazy. So that's not how the law works for murder. It's a specific set of things that can get you off. And by get you off, I mean sent to a treatment facility, which is not, equating to being free or a frivolous thing. It's not where you want to be either. But obviously, sometimes people prefer that to prison. Either they think it's going to be better, or they think that they can convince the people later on that they got better. And so then you get released because you were not guilty of a crime. So as soon as you're not a danger to yourself or others and all that stuff, in theory, you can be let out in the states that do this normally. So she didn't do it. Here's a question. Do defense attorneys go along with an insanity plea because there aren't other options? You think it'd be how hard it is to prove? Well, in this case, it's pretty clear that she's the one who killed her mother. So, what else do you got? I mean, you could try and argue that it wasn't first degree or something like that. It suddenly came upon her and it wasn't pre-planned. I mean, second degree or something. And in the case of, what's her name? The one that attacked her lawyer. You know what I'm talking about, Wisconsin, and cut her boyfriend's head off. She business. Yeah. So she did it. And there's not going to be a way to really convince anybody she didn't. So being crazy is the only way out of that one. And she is a form of crazy, right? But that's different than not knowing the difference between right or wrong. Yeah, 70,000 or tips or something like that. I think I lowballed that number earlier. Right. And not only something failed to be handed over to defense, but, not every 70,000 tips have to go to the judge in order for the search warrant to be valid. The point is, did they materially mislead the judge and kind of do it on purpose so the judge would give them a probable cause warrant to search Allen's home and vehicle that the judge otherwise would not have granted them? That if the judge knew this Odenite suspect was still out there, the judge might have said, I'm not going to give you the search warrant on Allen yet because I don't see it as more likely that he did it than another person. That's kind of the theory there. Yeah. Well, sometimes and it is true that sometimes if you murder people and then you're found not guilty by reason of insanity, you go to a facility, you'll get out later. In some cases, I'm not suggesting it's easy or that they just let people out in a frivolous way, but that's obviously what you're hoping for if you're taking that tact. Let's see. Checking out some comments here before we move off of Sidney Powell because we're getting there. But Judy, who's the local lawyer here who I did a stream with before, had covered this a couple times, and she had a longer video up about what I'm about to say. But we talked about Hadil Hikmat, which is local. She was local to us, and she came to this country to get married and start a family. And I still have this picture up because it kind of affected me because of the head covering that she's wearing indicates, I think, her appreciation to be in this country and for what it represented to her with her new family as a start to something better, right? And then her husband has been arrested for her murder, and that's not surprising. That was certainly my opinion when we were offline talking about it off the stream. And it's another domestic violence situation here. The Sheriff's Department says our thoughts and efforts are with Ms. Hikmat's family and the other families who contacted us about their missing loved ones. These kind of incidents are a reminder of the tragedy of domestic violence. It's a scourge that affects far too many lives and causes immeasurable pain and suffering. We urge anyone who may be in an abusive relationship to reach out for help and support. It's not easy, and that's good advice and strong advice. And I don't think she had a lot of avenues for that here because of the fact that she traveled from overseas and her family was not here. And so it's just awful. But he's arrested for first-degree murder and concealment of a natural death. I hope if that's the case and it's true, which it looks to be, that they have firm evidence and they can close this case out. At least her family's indicated they're glad to know that, that law enforcement has moved quickly on this. So, all right. So let's see this after the super serial thing. Why do some lawyers have Esquire after their name? Esquire is just like an honorary thing. I mean, you can use it if you want to. As far as I know, I'm assuming you're not a lawyer. I think if you look it up, it's just like a cool thing you can put after your name. And here's what I say about that. When I was younger, I didn't bother to do it anymore, but I would often, if I were addressing the other attorney, I would put Esquire after that to indicate that I honored the fact that they were an attorney, but I would never put it after my own name, if you see what I'm saying. But some people do, and I think that's a way to signal that I'm a lawyer, but and it's not like doctor or something. I see a comment actually here where you say, I think it's like MD for a doctor. It's nothing so formal as that, at least as far as I'm aware. I mean, maybe it could be in some other state or something like that. It's just a jazzy thing you can put on your correspondence to people, and sounds old school, and like you're writing your letter next to a lit candle on a desk like this. And I don't do it anymore at all, because it's a modern world. We want to get correspondence out faster. We don't proofreading like we used to. So there's a comment back on Allen. Sounds like crime teens would commit and make it look stage. Allen doesn't strike me as energetic to do all the staging. Well, I mean, okay, I hear you on that. And that is part of the defense theory that, first of all, they don't think he could do it. And second of all, they think it took more people than him. And of course, third of all, they say that the crime scene indicates beliefs that he doesn't share. But I don't know about all that. It's just unknown. And the person on the bridge doesn't look like a teenager to me or sound like one, because we have that voice on there. I think that's an older person than that, but I'm just thinking that. I don't know that either. So I hear what you're saying. Just, in terms of what actually happened at the murder scene, how can we really know for sure? Yes, I would write these. And okay, I'll admit this. I did write with fountain pens, and they don't do that anymore either, because they're, especially the good ones. The good ones are a big pain because you have to suck the ink back up in them, and you have to care for the nib, and then sometimes they leak ink. And all right, yeah. How would we know how energetic Allen was? Well, of course, the defense says he couldn't cross that river/creek, and I don't buy that. And I just, it depends on how much time you want to spend on the scene as to whether, you think he can do it or not. What you would have to do, and this is true if you have more than one person there, you have to find a way to restrain the girls. And particularly if you're going to murder one first, to keep the other one from going away. And then once that's done, though, it's a lot of work, the dressing, the moving around, the moving sticks around, stuff like that. But I mean, I don't know why you could not do that if you're an individual by yourself. So I agree with this. I mean, I respect the idea that people are trying to think out, what does the evidence show us in terms of what's most probable, what can we know for certain, and stuff like that. But I do not rule out that a single person could do it, whether it was Allen or anybody else for that matter. I just don't think that's impossible at all. But I don't know, now I would agree with this, that, that Allen's history, or at least his wife's history, I think, posted things on Facebook, shows them, hiking around, going to Smoky Mountains and stuff like that. And I think they were at that Bunyan Trail up in the Smokies. It's near Mount LeConte. Well, if you can go up that, you can get across a creek. Okay, that area there is pretty steep. We'll be back there in a few weeks, and not ready for it. So if he's doing that, then he's got some energy there. But it's an idea that it takes a lot of energy to create the crime scene as it's described. And okay, I hear that. And then another idea to say, well, he didn't have that energy. And to me, I don't know about that. Well, but if somebody wants to think that, that's okay. Ted Bundy cleaned out a sorority house. Yes. And thought of energy there. And then he also had that guy in Japan that stabbed 40 people in like 45 minutes or something like that. So once you're motivated, you can carry on. It's kind of like the Kohberger thing. There are some, I think, good points for the defense, but there's also the idea that he couldn't do it by himself. So in other words, it had to be this gang of people doing it, or more than one person, to be fair. So, well, I don't know that, and I don't know that makes him not one of the people, but I absolutely do not agree that he couldn't have done it in the time frame. Now, if you tell me I don't think he did it in that time frame, or it's probably couldn't do it, I can hear you. But impossible is not a word that I would use. If the evidence is strong enough to think somebody did it, except then you imagine it's impossible for something to happen like this, but no evidence of it, then that to me is not good critical thinking. If it's like that, probable is a far different word to use than impossible. And I think somebody went in there and stabbed those 4 people to death. Somebody did. And it's a supposition to imagine that it was 2 people coordinated to go to 2 rooms at 2 different times to do it, in order to have, could 2 people do it? Would it take 3? Why did it have to take more than one person? I don't know. I like the other comment was Bundy would do it. So, adrenaline, rage are powerful motivators, and some of these, I'm using the word serial killer, but that's not what he's being charged with. But it's more of a mass murder situation. But there's the idea that this fantasy arises in the person's mind, which I think it does. And then it goes and goes and goes. And a lot of times you'll see with these kind of people, they'll do other kind of crimes first, like peeping, potentially even entering. And then finally they end up acting out the extreme measure of the fantasy that they have. And they have a picture in their mind of what they want to occur. Probably in the Moscow case, the fantasy was not what happened. There wasn't a fantasy to go in there and have a sustained situation of having to kill 4 people, but something else was planned by whoever did it. And what happened was different. So that's my feeling on that. I still think he did it based on all the evidence I've seen, but it's early in the case. And you always want to keep an open mind if something comes up that shows you something differently. Why did Darrell Brooks not ask for a lawyer when he first got arrested? I haven't seen all the pre-arrest things that that some of the channels have out there, but I have seen some of it, and it looked to me, in what I did see, that he thought he was going to smooth talk his way past the police on that. That's what it sounded like to me, that he was trying to convince them of this, that, and the other. And, hell, he tried to smooth talk his way through his trial. So it wasn't very smooth, but that's my theory on it anyway. I expect that motivational evidence will come forth in prosecution of Allen, and potentially, so like, we don't know if the state has some more evidence that we don't know about. We don't know if I think we do have a pretty good, however, view of what the defense has, because this filing was 100 and some pages. How much could they have left out? But I don't know. I don't know if they have anything on him or not. The defense is certainly saying that the motivation involved this ritual stuff, but we don't have the state's response to any of that yet. I would just have to see what they come up with that. Yeah, the height of the bridge guy can be calculated by comparing known widths of the bridge. Does that match the height of Richard Allen? And my suggestion on that, respectfully, is that only within a certain range. Okay, that's my suggestion on that. However, if the defense wants to call an expert who can convince the jury that the video on the bridge proves that it wasn't Richard Allen because of the actual exact height and the shoe sole and stuff like that, if they can prove that, because I take that video as direct evidence of the person who was doing the abducting. If you can prove that that's not Richard Allen, then I think it would trump the other evidence. If you tell me, well, maybe it's not him, well, I already think maybe it's not him from the video, and maybe it is him. I can't tell who that is. But yeah, if the point actually gets proven at trial, then it excludes him in the video rather than it just could be him. Because I don't think the state's going to be able to call a witness who says that is him in that video. And then if the defense can call somebody who says that is not him and let me prove it to you, that would be a big problem for the state there. In my opinion, that it's not so precise. And I will say the efforts I've seen to demonstrate that wouldn't persuade me as a juror, but that doesn't mean that they wouldn't have somebody, who could come up and do a better job of that. So that's my opinion on that. But I hear what you're saying. That video is important, although I have yeeted out people who try to tell me that, it was manufactured and is fake and made up and stuff like that. I'm like, come on, people. But all right. So we've still got a lot of people talking about Allen, which I think is appropriate, because there are still some unknowns in the case. There was a lot of it kept secret to some degree because of the investigation and not wanting to put things out there. Some of it's for respect to the victims. And then some of it was because the trial said don't go out talking about everything. Yeah, it says they screwed up. Yeah. So, I've also seen people say, well, the 3 teenage girl witnesses give different descriptions of the guy's clothing. And to me, that doesn't indicate that they saw, going down the trail toward the bridge. I don't know. We're going to go out and walk in a little while unless I had some, I don't know that I'd be thinking, my wife and I might give counter descriptions on what we see somebody wearing as they walk by, but yet still be consistent with that we saw one person. So, I think it is fair to say that if you have the 3 girls just saying we saw one guy and there's 3 different descriptions of clothing, then you can't say, well, from that we can conclude that it was Allen because he had this clothing, because you have different descriptions. What I think matters to this is that they say they saw one guy. He says he sees 3 girls. All right. That's them, because he says he didn't see any other people. And remember, if his effort now is to move his time frame earlier, that he was there, say from 12 to 1:30, then why didn't he see those girls somewhere else? Why did he see the girls and the girls see him up there near the beginning of the trail? So that still to me is pretty persuasive. And then they have the timestamp photograph that's just before 1:30 when they saw the person. So, it's good to think about it. And, nobody needs to accept what I think about evidence as the same way they think about it. I'm fine with that. I don't like people making up things that blame the girls and say the video is fake. And somebody said, oh, I saw the defense files and they're going to be able to prove the video is fraud and stuff. I don't have time for that. But, if your idea is, hey, let's analyze the video and see if we can tease out whether we can know it's him or whether we can know it's not him, I respect that effort, even though I haven't seen one that convinces me yet. That's fair, because that's an important piece of evidence. So anyway, I think it's good to have the conversation about it. And And it's just clouded in some mystery because we have so much stuff that we don't know. And even if we knew everything, there'd still be things to debate about. And that's okay too. So the case carries on, and we'll see what happens with it. If he's the guy that did it, I hope he's convicted because it was horrible. If he had help and he was involved in it, I hope he tells who that was. And if he wasn't involved in it, hopefully that gets to the right conclusion sooner rather than later. I think they got the right guy in this case, but I wouldn't vote on it right now. I'd want to see the actual evidence. For example, the bullet thing or the unfired cartridge thing, one could assume that means that, yep, that's it. And then one can also say, well, oh no, that's junk science completely. But how can you conclude that to a certainty without ever seeing the evidence? So I think one thing we have in great supply in the country is certainty, right? I know this. I know that doesn't matter at all, or that puts him there and he's totally guilty. So I think you have to analyze it, think about it, look at how it likely will play out in court. And to some degree, we don't know that because it's different. It's not a spent projectile tool mark analysis. It's a case cartridge tool mark analysis and an unfired case cartridge tool mark analysis. If those are kind of descending orders, I think, of how convincing something likely would be, but they may have a great expert that puts it up there, or they may have a terrible one. Who knows, right? So until you can see the evidence, it's good to at least acknowledge the fact that my impression of the importance or the lack of importance of this evidence is subject to actually seeing the evidence and seeing how it plays out in court. So we can, reach opinions, but firm conclusions are tougher to come by, at least for me. Yeah, Darrell Brooks had lots of attorneys in the past, and he knew his way around the system. He should have had his own cubby hole there, I think, to receive notices and stuff. He's pretty much an honorary member of the bar. He's been there so many times, a frequent flyer customer. Well, that's a lot of cases, and we went a little longer than normal just because of discussing all these comments. So the allegation by the defense, I haven't personally measured him, is that Richard Allen is only 5'4". So that's what they say. And so there are people who say that you can calculate based on the images from the bridge video that the person there is taller than that. And so he couldn't have made himself taller, right? So therefore it had to be somebody other than him. And that logic is there, I agree. But I'm not convinced by the efforts at that precision of that from what I've seen so far. However, if that's a legitimate angle, then you'll see it in the trial, certainly. And I have to say, if the defense thought that it was that easy to show that that's not him on the bridge, why didn't they throw this in this Odin thing? They're saying, well, he didn't confess because Odin guards made him not confess. You think they could say that the state failed to tell the judge that they have a piece of video evidence that if any expert looks at it would actually exclude Richard Allen. All right. So why didn't the defense bring that up if it's that clear? I don't know. Maybe they're holding it for later and maybe they got work to do, or maybe they don't have an expert. I don't know. But I would say, at least from what I've seen so far, I don't think you can say it with that degree of precision unless somebody teases it out further later. I've seen people try, but that's different than court evidence. Did Brooks fire his public defender? Yeah, he did his last one. And what I've seen as of this morning, he has not been appointed another one yet. And then here's a comment. See, Allen's actually 5'6". But I don't know. The defense is saying in their court filing he's 5'4". I think they said that in their court filing. So what is he really? I would say this: if your whole thing about excluding him from the video is that he's 5'4", not 5'6", you better be real sure he's 5'4". Or simply change your screen name into the future, which is also a way to handle that. Because what if he's not really 5'4"? What if he's 5'5" or 5'6" or whatever? If the idea is to exclude him because of the bridge video, the precise height that he had, that matters. And the ability to precisely address that in the ratios and measuring this, that, and the other of the pieces of the bridge lumber and stuff, that's all super important. Every little bit of that, to the degree it's off, starts to stack up, and it increases the level of variance that your answer can give you. So I don't know. One thing the case has taught me is typos and mistakes are prevalent. Yeah, they certainly do happen a lot. But eventually, if his height really matters to that video, then someone's going to show precisely how tall he is, and there'll be some expert that says, I went there and I measured him, and You know, if he wants to be 5'4", then he'll try and get himself to 5'4" if he can. And I don't know. You know, it's like OJ with the glove and stuff. So we will see what happens with that. Anyway, I don't want it to carry on too much further because I know you guys have got things to do, but we will catch up on some of these cases later. And I did do some commentary on the Richard Allen case earlier in the week that a lot of people watched and got some good discussion out of that I appreciate. And I will talk to you guys later and hope you have a good weekend. Thanks. Bye.